All right, there we go. All right, welcome everyone. This is Curt Barone.
And Brad Pinsky.
All right, and we're here for another edition of Fire Law Roundup for, I guess it's supposed to be for the 24th, but it's actually, we're doing it on the 22nd.
Yes.
22nd of April. All right, man, take it away.
Okay, so we're going to go over to Buffalo, New York, basically. This is the city of Lockport, so we're in the Western New York area. And here, really, we have kind of an interesting thing happening. We have the city of Lockport, which wants its fire department to start providing ambulance services, which is fine. Ambulance services are becoming very tough to, kind of rely on others. So the city probably wants their own. But what's being challenged is the way they're doing it. So the city has a board of trustees and a mayor. And what happened allegedly, this is just a lawsuit, and it's a lawsuit that challenges the administrative procedure by which the vote to hold the to reinstate the ambulance and to get their own operating authority to start running their own ambulance. That whole process is being challenged, and allegedly even the president of the union is in on it, and the union probably should support it,
as they should be.
Yeah, right. It seems like it'll support them and benefit them. It maybe increase their their ranks. But in any event, what basically happened is in New York State, like probably most other states, there's something called the open meetings law, and the open meetings law requires that all discussions and votes, both discussions and votes, have to be held in public. No backdoor votes. There are some exceptions for executive sessions, but there's a very small list of exceptions. And frankly, the decision to start your own ambulance service is not one of the things that's going to fit into those exceptions that you can go into executive session for. You're going to have to hold that in public. So there's this lawsuit basically says, listen, there's a lot of things that happen. One, there wasn't public discussion. Two, they come out and they vote. But the vote was actually, they had a couple in favor, they had 3 in favor, they have 2 against, and 1 abstained. And then, so I don't really understand from here going forward. The mayor said he's going to break the tie. Now, there was no tie. It was 3 in favor, 2 against. An abstention under the law is a no vote, pretty much under common sense, too. So I don't know how the mayor then decides he can vote to break a tie, but 3-2 isn't a tie anyway. So I don't totally get that. In any event, I think really maybe what was saying is maybe they need 4 out of the 7, which would be a majority. In any event, so that's what's being challenged. And they're doing it under a process called an Article 78 challenge, where citizens and residents, and there's some ex-board members, can challenge it. I don't know why they would do this. I mean, really what the head scratcher is why would they do this in private? Why not just come out and have a very public discussion and talk about whether you should be reinstating the ambulance? I don't understand the secrecy.
I think I do, especially with the sequence with the union president, because there were some allegations that the union president went into an executive session, which it should only be the people on the board, okay? Unless there's a grievance, and unless they were negotiating, trying to finalize the grievance. And now I would think the people who were involved in the lawsuit, though, would have been privy to those types of discussions, because typically you have a grievance. I consider a grievance to be a legal proceeding. It's not court, but it still is, you've got legal things that have to be done. You got timeframes that have to be, and then it can end up going into arbitration. But at any rate, you can resolve a grievance through a settlement. And any sort of legal proceeding that needs to be settled should probably be discussed in executive session.
But here we don't know there was a grievance, right? This was just
we don't. I'm speculating. Oh yeah, no, pure speculation on my part.
Okay.
You were saying you couldn't understand, and I'm saying, well, maybe there was a grievance, okay, and also the fact that they used to provide EMS, but they no longer provide EMS it could be a grievance, could be an unfair labor practice, could be a bunch of different things that union filed to get that reinstated, whatever it may. Now, that total speculation on my part, but here's the thing. Why would the union president be in an executive session? That's what was in the complaint. There's no reason why they would. Well, no, if we got settlement discussions going on, maybe there is a reason why they would be in there.
Right.
Okay.
Now, the interesting thing is under the New York State open meetings law, you have to, the courts have held that you can't just say personnel matter
Right.
or, litigation. You have to be a little more specific. So the resolution, if it was done right, we would have known why they went in. But here, I'm not even sure they actually, to go into executive, you have to hold a publicly noticed meeting, sit in front of everybody and say, we're making a motion to go into executive for this reason. And then you go into executive. The public has to see you go in. And a lot of these municipalities just assume, oh, well, since no one's going to hear what we talk about anyway, we just won't tell them we're going in. And that violates the law. So I will tell you, if what is alleged is true, they will get a reversal of this. I think they will. The courts are pretty favorable to supporting the open meetings law in New York, and they will probably get a reversal. All you get is a reversal of decision, then they could go forward and do it again anyway. So they waste some time, waste some money, get some egg on their face. But ultimately, if they want to have the city start providing ambulance service, it probably just takes a majority vote of the board to do so, and the union's agreement.
Yeah, and there's another part that I thought was interesting in this, in that there was an allegation that one of the council people's son is a firefighter.
That's the most interesting allegation, but I think it's so far-fetched.
Yeah, I mean, how is that a conflict? Because think about it, if you had a council person whose son was a police officer and you're going to maybe enact a new traffic law or a new regulation that people have to follow, you could be benefiting. I mean, how
far down the chain? Yeah.
Right. There's no direct connection between that.
Although the Attorney General in New York State, look, for everyone who watches this, watches us, I'm in New York State, so I'm more heightenedly aware of New York State specific cases and laws. But the Attorney General in New York State said that if an employee of a municipality where a board member, right, is directly related to, which in this case, if they could be at all financially benefited, then that board member has to recuse themselves. And I could see instances, maybe they'll get the promotion, maybe the union wants a raise, maybe, maybe there's some indirect.
I think if this was a pay raise, then yes. If it was a promotion, yes. But to resume ambulance services, there's a lot of assumptions.
Right. It's so far early in the process.
There's a lot of assumptions that are within that. I mean, imagine a school system where, you could have a child in the school system that's going to benefit from maybe a new program or new funding. You can't be a parent and on the school board because your child may benefit from
so far-fetched
better funding. It's just like there's got to be a reasonable line drawn.
Right.
So
anyway, okay. Well, we've beat the literal crap out of that one. So.
Well, I do want to point out Lockport came on my radar screen right around the time I started my database back in 2010. Oh, wow. And there's been, I think this is, if I'm not mistaken, this is the 13th civil suit that I've got between the Lockport firefighters and the city or some variation thereof. Awful lot of litigation. I don't know how big Lockport is. Certainly
it's a city. I mean, it's not Manhattan, it's not the city of Buffalo, but it's a good sized city.
Buffalo, right?
No,
it's not Syracuse.
No.
So, but at any rate, it just seems like there's a little hotbed, and I always there's a number of cities around the country that I don't know. To me, the last thing you want to do is have to file a lawsuit. And I'm saying that as an attorney, but why don't all cities have these types of problems? What are they doing right? What is Lockport maybe not doing right that is leading to a lot of this contentiousness?
Right. And it seems it appears, right? All we know is what it appears like. It appears like there was some backdoor negotiations and discussions that probably should have been held in public, or at least that's their allegations. So I don't know. Clearly the board seems divided, and frankly, on bringing your own ambulance service into place, I don't know why they'd be divided. But I want to make a note. There is a bill being placed in, it's supported by the Senate and the Assembly. It's got a good chance of going. And if it passes, it will require every municipality to either provide or arrange for ambulance services. That's not the law today. And many entities are simply relying on the private who just happens to come here, or on mutual aid, or they make no arrangements at all. So I would tell you, the city and everybody else who's trying to get their own ambulance service, now's the time to do it, because if this law passes, everybody's going to be scrambling to figure out how to do it. I'm ecstatic. My business is going to be booming. But this has a real chance to go. So ambulance services are tough to find. I don't disagree with why Lockport would do it, but why would they need to do it in secret?
Yeah, no, for sure.
Okay. Let's a quick one, really. Tyre Nichols. And we'll focus on the EMTs here. The firefighters and the EMTs are now named in the Tyre. Is it Tyre? It's Tyre, right?
Tyre Nichols. Yeah.
That's how I always hear it on the news. In any event, this has been all over the news, but now they've, among everyone else, now the firefighters / EMTs are brought in. And it's pretty damning. I'm assuming the way this 130, page complaint was written, this is a long lawsuit. I'm assuming that there's obviously tons of video, because what they describe appears to be a, step-by-step watch of the video. And what they describe in this lawsuit is that the EMTs either stayed in their engine, or that one of them, they said, well, he got out, got to the patient's side, but he pulls out a BP cuff, stares at it, and sticks it back in his bag. And then Tyre Nichols slumps over. And they really say nothing happened until 19 minutes later, when EMTs showed up, and two new EMTs showed up and actually started giving medical attention. But by then it was too late. If this is on video, I'm not quite sure why this is needed to be sued out, right? Because you're sitting there in front of somebody doing nothing, you pretty much lose.
Yeah. Yeah. I think on the civil rights part, I'm on the wrongful death part, there's a causation, I think, issue. Civil rights wise, yeah, absolutely. And, but causation wise on the wrongful death, I mean, maybe there is, maybe they'll get expert testimony to connect the dots. And
yeah, I don't know. It's, horrible, obviously horrible stuff. And I really hope no EMT, paramedic, firefighter, whatever, withhold care. If that's true. And again, I presume there's a video. I haven't seen that part of any video, but, you hope it's certainly not true. It doesn't look good for anybody. And, who knows what the police are saying. It sounds like there's no audio on any of this, which I'm shocked, because I would think a lot of it would be on the cop's body cam. But there was a lot of speculation about what was said, but very little speculation about what was or wasn't done as far as what would be caught on a video. I don't know. Do you know whether there was audio of it?
I don't. I don't.
That's the only thing I can come up with, is maybe the police were saying, don't touch him or whatever. Who knows?
That I don't know. And I just, it was an engine company. The 3 firefighters were an engine company, and I guess they were waiting on an EMS unit that took whatever it was, 19 more minutes to get there. So,
the lieutenant didn't get out of the truck. I mean, it's very strange, all very strange. So, okay, well, let's go to maybe not a stranger one, but just another one. And I got to tell you, I do not understand this. I hope you understand this better than me, but we're going to go to Denver, where a firefighter without an attorney and without the union support is suing the city and the union after he says he was terminated based on a disability. And look, the short facts are, maybe you understand this better than I did, because I had to read this 3 times trying to figure out what is going on. He gets injured. He's placed on light duty. He says that the city and the department kind of delayed his medical treatment. They tried to use that injury against him to declare him unfit for duty, that they continually delayed his treatment, and they wouldn't offer him further medical treatment. And then they said, look, you're too injured to be a firefighter and you're terminated. He tried to apparently grieve it with his union. His union wouldn't support him. I'm suspecting there's a lot more than what we know behind the story.
The fact that it was filed pro se, he didn't have an attorney. It's actually pretty well written. I mean, if you look at chunks of it, pieces of it are very well written. But in terms of comprehensiveness, I think he's missing some. When I started reading it, I thought he was going to be alleging an ADA violation, a disability violation, as you read the complaint. But he's alleging conspiracy, insurance fraud, or insurance, let me get it right here, bad faith, breach of the insurance contract, breach of contract against the city, and then breach of, he speaks about breach of the duty of fair representation on the part of the union, but then he sues the union for breach of contract. So I think he, if he doesn't have an attorney, he probably should get one. and clean up the complaint, because it may have an early exit if he
Maybe he
doesn't.
couldn't get one. Maybe
Well-
when he sat with an attorney, the attorneys listened to it. I mean, these types of claims to me are not good claims that a judges want to hear, right? The ADA claim would have been a good, right? That will get a judge's attention. But when you start claiming conspiracies and things, I think judges get turned off. They're too busy to listen to what you, how do you prove it, right?
Well, it could be he went to attorneys and either they didn't want to go in the direction he wanted to go in, or they wanted too much money. This is not the type of claim that an attorney is going to take, on a contingency. It's too
Right.
speculative. So, he may have gotten a price that it wasn't something that he could afford.
Yeah.
I don't know, but
Very possible.
yeah, very difficult, but folks can read the complaint and, draw your own conclusions about it.
Okay, I think the most interesting one we have today is the last one. We have 4 because we're doing this on a Saturday night because I got to be somewhere else on Monday. But here, and this is kind of a continuing saga, we have 4 male, right? I think they're all male firefighters in Washington State. Now, it's like the second Washington State thing we've had, or third in last month.
We had the same scenario, but it was with a different plaintiff, but all 5 of them were male. Yeah.
All right, so now we have 4 more, and they claim that their training instructor, who I think was a supervisor, right? Although probably shouldn't have been.
He shouldn't have been. And there's a couple of things. Go ahead, go with your story. But
well,
he had only been on the job
he only been
on the job 2 years. So
yeah, and so look, the short is he was sexually harassing them, and he was using inappropriate language and making inappropriate comments to these individuals. And because he was a supervisor that the municipalities deemed legally to know that it was happening, he's gone, right? They fire him, I think, but this still happened at the academy. And it's unbelievable when you get 4 or now 5 people making these claims, you're in a lot of trouble.
Yeah, really unfortunate. And I know an awful lot of firefighters, when they hear sexual harassment, they roll their eyes. So when they have to go for their annual refresher training on sexual harassment, they kind of roll their eyes. But I think when you think about the facts in this one, where you have a male instructor who, I don't understand how he's an instructor, because he's only got 2 years experience.
I know.
But he somehow gets himself in a position where he can be an instructor both at the Everett Fire Department, but also at the Snohomish County Fire Academy. And the other suit we had to do with someone who was in that fire academy. But these 4 complaints happened at the Everett Fire Department's academy. But was engaging in not only inappropriate comments and different things, but also some physical contact that made people very uncomfortable. And I think it's a good fact pattern. I think I'm going to be using some of the factual allegations when I do my training, without naming names here, but because I think it's an interesting fact pattern. Because when things happen, you say, well, what if a male instructor came up to you and did this?
Right.
And
I think one of the really interesting things is this. It's 5 people, right, who are making this claim, 4 or 5 people making this claim. If this was one person,
right, we
would be viewing this very differently, because the proof is harder. It's no less realistic, right? It's no less truthful. It's no better that it happened. But if it was one person coming forward, we'd be like, you're probably wrong. You're lying. You're disgruntled, right? Right away, the mindset, just as you said, when you hear sexual harassment, things like that, is, come on, right? I mean, this happens all the time. Suck it up, buttercup, all that stuff. But you get 4 or 5 people now making pretty harsh claims that this is continuing to happen.
It's corroboration. It's corroboration. And I do a class on credibility determinations. And the best way of establishing credibility is through corroboration, either from another witness or evidence, video, photos, or whatever. But whenever you can corroborate in some way, that speaks toward credibility. And we've got 5 people now with shockingly similar stories about what this particular instructor did.
All right. What the part I didn't see in there is any reference, and it doesn't matter because he was a supervisor, right? But somehow, but I didn't see any reference to or any allegation that we told people above him that it was happening. Now, that's not required. That's not why, for the viewers, that's not why I'm saying that. The city is deemed to know what's happening because he's a supervisor. And that's why probably you, me, and every other attorney says, look, when a manager harasses someone, you lose. The question is just how badly, right? What did the city, the employer, do in response to learning what happened? So that's my question. Was this reported at some point? Because I didn't see that.
Yeah, I didn't see the complaints. And, there's certain courts, certainly all the federal courts, we're usually able to get the complaints pretty quickly, if not the same day, within a couple of days. State courts is a little bit more difficult, and I have not seen the complaints. I'm sure the complaints would outline that. Yeah. But certainly, with hostile work environment claims, there has to also be some knowledge on the part of the employer in order for the employer to be liable. Certainly the instructor personally could be liable, but if they're going for hostile work environment, they're going to have to show that the department was on notice. And, this guy was teaching also at the other fire academy. So there's questions about, were things that happened at the other academy brought to the attention? And, my guess is at some point, yes. But, when you only hear one person's side of it, you may say, oh, I'm not convinced. Now you've got 5 people saying it. Yeah.
Right.
A little different.
Very interesting. This is very, very rare that this happens. I will say on a totally different topic, but the same. So this week I settled a case where I represented a very strong Black lesbian female. And when I say strong, not only mentally, but she is very physically strong. And she went into the women's restroom. When she came out, the dean of the school was there, and in front of 20 other people said, that's the women's bathroom, not the men's bathroom. And it traumatized her. But then it happens again 2 days later by another lower individual, but does the same thing, embarrasses her twice. Now she's mentally, anguished, and she's on meds, and she's in therapy. And I'm telling you, this woman is stronger than strong, mentally and physically. And yet you embarrassed her, you mortified her. And I can only imagine, and there, I want to say, the employer came forward and said, we agree we did it, because it was a university, and they implemented training. Look, I got them to pay her some money, nothing like it would have been had they denied it. We had a fought over it. But these types of things constantly happen where people say stupid things, inappropriate things, but sometimes it's mean things. Sometimes there's a pattern. I guess my experience here, this was the first good experience I've had when I said to somebody, look, you owe this, individual some money, and you got to train, and you got to stop this. And they're like, right, we're at, an institution of higher learning. But here's my point. My point is, the culture of the institution of higher learning is against intolerance. Right? They immediately say, this ain't happening. We're changing it. Yes, we're sorry. We're not going to fight you. Yeah, we had to get to a reasonable settlement number to address some of our concerns. But the culture was anti-tolerance. So my real question is, what's the culture of the fire service? And it's such an obvious answer, right? This would never continually always happen. I mean, how many discrimination claims are you and I going to talk about? If I have to recite the McDonnell Douglas test again, although I just included it in a lawsuit, if I have to cite it again, 70%, right? 70% of suits in your database are.
A big percentage of them are. Yeah. We've
got to change the culture of the fire service. And I don't know how to do it, but we're not going to do it. Lawyers are doing it, right? Without the lawyers, we wouldn't be changing the culture, but it's not happening fast enough.
It's not. It's not. And we can beat our chests and beat our, my wife told me a story that I think you and I have gone over it. I don't think we've gone over it here, but she just retired, but she's a high school teacher. And, unlike when I was in school, there's a lot of folks with various disabilities that are mainstreamed. Okay. And back when I was young, they were in separate schools, and some of them weren't even in schools. They were in hospital beds, and now they're in wheelchairs and they're in classrooms and, special needs types of students. Okay. And she was telling a story about one of these special needs kids who had a nurse with him. He's in a wheelchair. And in class, he farted. Right. And she said, nobody, like it, kids just ignored it, just like it didn't even happen. Now this high school kids, and you think about when I was in high school, somebody farts in class, guys falling out of their chairs, and
right.
Oh my God, open the windows, and all the
Picking on 'em for the
hysteria,
next day,
everybody laughing and all that stuff. But I think the kids today are socialized differently than we were. And that is eventually going to find its way into the fire service if it hasn't already. I'm hopeful. I mean, I'm hopeful that it is. Now, she also said if the captain of the football team did that, then the behavior would have been typically what it would have been back when I was in school.
Right.
But the fact that someone who's has unique needs did it, the kids recognize that, and I that gave me hope. It gave me a lot of hope that eventually things are going to change, not necessarily going to change through what we do, but through some changes culturally in society are eventually going to find their way in. That's my hope.
One of the things you and I should do, we should do it could be a 2-day series easily, but we should bring in the chiefs and the administrators, because ultimately they're the ones who have to do this, but change the culture, prevent most of your lawsuits. If they would change the culture, stop the bullying, the hazing, the pranks, the jokes, the discrimination, the comments.
Bullies don't know they're bullies. Bullies don't. So we can yell and scream. Bullies don't know they're bullies.
Right. But the chief can put an end to it.
That's why we have designated adults that we call lieutenants and captains in the firehouse with the kids, so that they can, put a stop to it. But sometimes it's the lieutenants and the captains that are actually the perpetrators, or it's easier for them to just kind of go along. And that's a problem. Yeah.
It's just a sum up. It's rare on here where you and I are talking about an accident, maybe the accident where an engine hits somebody and kills them, Kansas, right? But we're almost always talking about discrimination and something like that. And this would be a much shorter show, and a lot of lawyers would be out of work if the chiefs would step up and end it. And I really think we should educate the chiefs. And if the chiefs aren't going to do it, get a new chief.
Yeah.
So
yeah.
Okay.
All right. Let me just throw in one more thing, only because and you didn't have the opportunity to see this, but a couple of other cases got by my desk this week, 2 AFFF lawsuits, and I just want to point them out. Now, one of them is just a single fire department. It is the Three Rivers Fire District in Massachusetts suing the foam manufacturers, and I usually see a couple of those a week anyway. The other one is pretty interesting, Brad, and I should have blogged about it, but it's the Association of Fire Districts of the state of New York.
Oh, okay.
Versus the AFFF manufacturers. Oh. And they did name one fire department as a plaintiff, the East Fishkill Fire District, which is, I believe, is up in your.
I represent them. I know them.
Okay. Yeah. So point being, the question I had, and maybe you can think about it, is does the Association of Fire Districts have standing to bring
as much as maybe the IFF does against the NFPA in that suit?
Yeah.
Your members, but it would be an interesting thing. And I'm sure there's a lot of cases that talk about whether a corporation, it's a membership corporation where they pay dues and belong. So they're members of this corporation. And so do they have harm though? Right. To say our members have harm as members. I don't know. They should have easily been able to get a bunch of lawsuits or a bunch of fire departments signed on. Yeah. Directly. That doesn't make sense. And even, would-be plaintiffs. I don't know. I'm shocked, but maybe they must have done the research, I presume.
Well, I don't know, either that or they kind of jumped the gun on it, but I just maybe they're hoping to get get it in court long enough for them to start filling up like a class action and start recruiting departments.
I know their attorneys. I don't specifically know who's handling this, but I know the attorneys for the association. They're, smart people. And I've seen them in court on both sides of the courtroom. But so I think I would credit they probably have some basis to think that they have standing, and beyond that, have some damages. I mean, that's the hard part to me is, okay, even if you have standing, what is the association's damages?
Right. They can say our members have damages, but that's not enough. You've got to have the damages. If you're a plaintiff, you've got to have the damages.
Right. So that's the part that confuses me, but who knows?
Who knows? Who knows? So. All right. Well, I think we're at the end of another session here. And please, if you haven't already subscribed, please consider subscribing. Please watch. I think we're somewhere around 600 hours now short of our goal. Once we get up to 4,000 hours, then we finally reach that plateau where we're hoping to get to. And we've got enough subscribers. We just need about 600 more hours of viewing time. So,
and if you want, we'll speak for 600 hours, and one person has to watch, or we can divide that up.
That's the thing. They've got to watch. So, all right. Well, that's going to do it for another edition of Fire Law